Welcome back, my dear boys and girls. Today we are continuing with chapter 11, Indian Judiciary, part 6. We are discussing the last two topics, that is Lok Adalat and the independence of judiciary. Let's start with today's topic. Come to page number 9090, last heading, Lok Adalat. Lok Adalats or People's Court. Another name for Lok Adalat is People's Court. Gujarat state is first to start Lok Adalat to provide speedy and economical justice to the poor, weak and exploited section of the society. Lok Adalat is a traditional Indian method to relieve the overburdened court system by providing relatively quick arbitration. That is, fast way we can come to a solution. The decision have statutory status under the Legal Services Authority Act of 1987. Under this act, the verdict made by the Lok Adalat is deemed to be of the same legality as fines from the civil court. Final for all the parties and not subject to appeal. If the parties do not recognize the findings of Lok Adalat, they may initiate litigation by approaching the court that possesses the appropriate jurisdiction. Lok Adalat function voluntarily even on Sundays and holidays at the district and taluka headquarters as per the convenience of the petitioners. According to our convenience, Lok Adalat is functioning. Now, generally, Lok Adalat hear the cases of accident and its related compensation. Then divorce, alimentary, general debts, personal complaints, police complaints, etc. Normally, they solve this type of cases. Lok Adalats consist of advocates, social workers, educationists, reputed citizens, businessmen, police officers, insurance officers, judges and the judicial officers. Normally this type of groups are there because they want to solve the issues very fast. So the experts are sitting there and they will solve the problem very fast. Here cases are settled amicably such that both the parties are satisfied and agreement mein aa jata hai. There are no penalty or that type of things are very less they are handling. The cases was fought in the Lok Adalat are neither won or lose. No one will won or lose. There is there is an agreement they are making. Lok Adalat save time and money. That is a speciality of this setup. Many pending cases are solved. All the judgments of the Lok Adalat are backed by the law. Therefore, Lok Adalat has become a center of attraction. Please underline the last three sentences, that is Lok Adalat save time and money. Many pending cases are solved. All the judgment of the Lok Adalat are backed by the law. Therefore, Lok Adalat has become a center of attraction. Maybe give reason, this type of questions you can expect from this section. Now, come to the last point, that is independence of Judiciary, page number 91. The Indian Constitution has kept the judiciary independent, firm and fearless from the legislature and the executive for the protection of the fundamental rights of the citizen, for the social, political and economical equality and for providing justice. This already we have discussed. See, Indian Constitution is free from we can work fearlessly. They are not supposed to depend on legislature or executive. The judiciary should not be inclined or biased towards the government. Government ka side lene ka nahi hai. They can stand as an independent organization. The terms and conditions for the appointment of judges, the appointment process, pay scale, transfer, promotion, retirement, etc. is taken care of by the executive as per the constitutional provisions. Everything is written very clearly in the constitution, and that things will be looked after by the executive of the country. The judges are appointed for a specific period of time. The executive cannot remove any of the judges due to their will or any political pressure. So, nobody is supposed to put their hands over the judiciary. The judges and the judges can work fearlessly. The pay scale, the terms of service, promotion, transfer, benefits of promotion, pension fund of the judges cannot be altered. Altered means changed. During the terms of service of the judges, any of their behavior or their judgments cannot be discussed or critically reviewed in the parliament of the legislative assembly. The judges and their judgments are beyond our critical reviews. We are not supposed to give any critical reviews over the judges, over the judges' judgments. Judges after their retirement, please underline this. The judges after their retirement cannot carry out their practice in any of the court. Please underline it, give reason. Why the judges are not able to? Because the purpose is to empower the judges to perform their duties fearlessly, honestly, self-reliantly, independently and firmly, so that the judges can impart true, transparent and quick justice. Why they are not able to do any work or cannot practice there's in any of the courts? Because the purpose is to empower the judges to perform their duties fearlessly, honestly, self-reliantly, independently and firmly, so that the judges can impart true, transparent and quick justice. The Indian Constitution has given the judiciary an independent, impartial and uniform place. The case of public welfare, the question of the public welfare or important problems pertaining to public welfare can be written on a simple postcard or an ordinary letter to the Supreme Court. Public welfare related or the question for public welfare or important problems pertaining to public welfare. If anybody wants to submit a case regarding public welfare or want to know something, they can write in a simple postcard to the Supreme Court. postcard और ordinary e-lend में आपको एक letter, इतना खर्चा भी नहीं है. postcard, I don't know whether anybody of you have seen the postcard and letter e-lend. So एकदम very cheap पेपर है, वो पोस्ट ऑफिस में मिलता है, उसमें लिख के आपको सुप्रीम कोर्ट में भेज सकता है. Here you could see two things. The first one is a postcard and the another one is an envelope. A postcard is a piece of thick paper or thin cardboard, typically rectangular in shape, for writing and mailing without an envelope. One stamp, normally that letter is an open letter. Then the earliest postcard dates back to 177 years to 1840, when an Englishman named Hooke, Theodore Hooke, sent one to himself. See, these postcards may be, now it is, even though it is available in post office now, normally people, those who are having the habit of stamp collection and first day covers, they are having this type of postcards with them. The other one which is there, that is that one is the inland, that is a closed letter. It cost around 2 rupees, the cost of that one, that you have to purchase, both you have to purchase from post office and you can write the letter and you can send it to the concerned person. That's what I was talking about. When we were discussing about the judiciary, there you can use an postcard or simple inland for writing a letter, and you can write if you want to know about the things to this, you can write it in a simple postcard or an ordinary letter to the Supreme Court if you want to know about the cases of public welfare, some things related with the public welfare, the questions of public welfare, or important problems pertaining to public welfare. Okay. In the past, the Supreme Court has treated such matters as petitions and has given trend-setting judgments. This has proved the vigilance of the judiciary in the public. Coming to the last paragraph, at present there are about 3.5 crore pending cases in our judiciary. Many cases are pending because the reason is insufficient number of court, judges and staff. And because of less staff, less court, less judges, we are not able to solve many cases on time. So, the present central government, they had undertaken the task of reframing 1,500 old and irrelevant cases. They are trying their level best to set up new court or appointing many judges, and they want to solve this number of cases. So, with this, we come to the end of today's lecture. From the next lecture, that is on Tuesday, I will start giving question answers. Only the first lecture we have discussed the question answers. In the next lecture, totally I will be discussing the question answers. So, please get ready for that. I know very few notebooks are with the teachers, rest all the notebooks are with you people only. So, the answers I will be discussing, or you can keep this for your reference, and while writing the notebooks you can use this next lecture. Okay. With this we come to the end of the chapter. So, we will see you in the next lecture with the notes. See you. Till then, stay safe. Bye.